Hello and welcome back to Case Closed, the podcast that makes sense of legal concepts one episode at a time. Today we're taking a look at something that doesn't always involve judges and courts. It's called Alternative Dispute Resolution, or ADR for short. So what is ADR? ADR stands for Alternative Dispute Resolution. It's basically a collection of methods that help people resolve legal disputes without going through the formal court process. The most common types are negotiation, mediation, conciliation, and arbitration. Let's break each one of them down. Negotiation is the simplest form of ADR. It's just two parties trying to come to an agreement, either directly or through representatives. This could be face-to-face, over the phone, or in writing. The aim here is to reach a settlement, and it can happen at any time, even after court proceedings have started. It's flexible, often free if no lawyers are involved, and keeps things private. In mediation, a neutral third party, the mediator, helps both sides find middle ground. The mediator doesn't take sides or make decisions. Instead, they shuttle between the two parties, encouraging them to compromise. It's voluntary, less formal, and used a lot in family disputes. Services like Relate offer mediation. There is also something called a mini-trial, where both sides present their case to a panel, often including decision makers from each party, and try to reach an agreement with the help of a neutral advisor. Conciliation is similar to mediation, but the conciliator takes a more active role. They'll suggest possible solutions and grounds for compromise, but just like mediation, the outcome is only binding if both parties agree. ACast, the Advisory, Conciliation and Arbitration Service, is a key example here. They help resolve employment disputes, including industrial action like strikes. Now, arbitration is a bit different. Here, both parties agree to let a neutral arbitrator or a panel make a legally binding decision. The rules are set out in the Arbitration Act 1996, and many contracts include what's called a Scott and Avery clause, which says disputes must go to arbitration instead of court. You'll find this in things such as building contracts, mobile phone contracts, and holiday packages. Hearings can be based on written submissions, this is called a paper hearing, or in person, and they're usually private. Lawyers aren't always needed, which can save money and reduce conflict. The arbitrator's decision is called an award, and this is legally binding. It can only be challenged for serious procedural mistakes and legal errors. So let's recap on what we've learnt so far. Negotiation is informal and can happen at any time. Mediation involves a neutral helper, but no decisions are made for you. Conciliation is like mediation, but the conciliator suggests solutions. And arbitration is more formal, legally binding, and follows agreed rules. ADR helps save time, money, and stress, and in many cases is actually required before heading to court. That's all for this episode of Case Closed. Don't forget to follow the podcast as well as following us over on TikTok and Instagram. Next time we'll be evaluating the different forms of ADR. Until then, keep revising.